So good morning, everyone, and welcome to our colloquy for week 5. So we are already halfway through this semester, and this is the first part in Tumba where we will cover chapter 23. But before we start on the chapter itself, let's just talk a little bit about your results for test 1 and a little bit about the assignment. So these are the marks. As you can see, the average is quite high. It's 16.42, so it's an A. And this is out of 260 people who sat this test. Some of you, of course, don't sit this test because they are incarcerated students and others offline. Now, as you can see here, almost half of you, so almost half of the 260, received either an A or an HD. And that's what we expect. So it is an easy course, as we said from week 1. It's just an introduction to law, introductory course. But don't sit on your laurels, because it gets harder as you go through the course. So you should start really working on your assignment. And as I said, there is a formative assessment. You are welcome to email it to me as a draft, and I will give you some comments that hopefully will improve your grade in the summative assessment. And of course, you will have to take the second online test. Remember, that's another 20 questions, but each question on that test is worth only half a mark. So it's worth 10 marks. And then we get to the real business of the final exam. Now, just let me give you some rationale for what we are doing here. Many of you have realized that these questions are so simple. This is really a formative assessment. All I want is for you to open the book and read the book. And the same thing with the assignment. All I want from you is just to understand a little bit about ILAC, how we use the Wentworth-Miller method, and what you will use for the assignment is a very reduced, distilled version of those. Again, it's pretty much a formative assessment. And the same thing for the last test. Why is that? Because usually in law, when I took law, we used to have only one piece of assessment, and that was the final exam. 100% on the final exam. Can you imagine the anxiety? So it was a crisis for everyone. So we'll make it easier this way so that you can have at least 50 marks to pass. There's only one hurdle in this course. You don't have to pass the final exam. You just need to get 50 marks. So there's no crisis. But still, the important component, the one you really have to pass to get an A or an HD, is still the final exam. And we will talk about the final exam much, much more after the break. All right. There was a question earlier today about the assignment. So the assignment, as you can see, is due on the 18th at 11:55. And the question was, what kind of references do we need? So all of this, of course, is detailed in this assignment details document. But let's just quickly look at it so that we are all on the same page. Okay. So what I want really to talk about is the bit about, I think it's number here. Okay, so in number 5, clause 5 says, give references for your answers in addition to the required reading. So that's the reading I took you through for the second week tutorials, both in Tumba and Springfield. That has to be one of the references. But you need 3 altogether. And the question was, can we reference the textbook? And the answer is yes. Just make sure that you reference the textbook consistent with the referencing style that you're going to be using for your assignment. Now, I'm not too worried about which referencing style you're going to use, okay? Just pick one and use it consistently. If you have problems with that, consult with the library. You also have another resource, which is the Student Center. You can also go and talk to them. And of course, you can always come to me. That's enough for that. On that, so let's continue now with the substantive part of our colloquy. I've given you a handout earlier today, and I don't usually give handouts. So hopefully that will give you an indication of what I'm doing here. Of course, you can bring this with you to the final exam. It's an open book exam. You can bring the handout with you. And this chapter is going to finish off on the area of torts. These are the intentional torts. Okay? So they are different from negligence in that sense. And we have a lot of them. So what we want to do really is to distill to the elements, but that's not the only thing you have to know. You still have to look at the defenses and the remedies. And that's, of course, spelled out to you in your textbook. So we'll start on trespass. As you can see, there are 6 theories or cause of action under trespass. Okay? So trespass could be to the person, to the land, or to goods. Under to the person, this is the tort theory. So you'll find assault and battery. And today, of course, under the, for example, in Queensland, under the criminal code, they are lumped together into one action. Okay? There's false imprisonment and there's nervous shock. Under the goods trespass, we also have détenu, which comes from Old French, which means basically to detain, and conversion. As always, we said that as a legal analyst, as someone who wants to have a feeling for how the law is analyzed, you always look for the elements. So once you have decided which premise is the most likely to succeed on the facts, you will have to look at the elements, and that's not the end of your analysis. You then have to identify the legal issue within these elements, and that's the starting point for your exam part B problem solving questions. Here we'll have trespass to the person. Again, you can elementize. There must be a direct and intentional, that's why we call them the intentional torts, interference to the person of the plaintiff, and this is actionable per se. We said per se simply means that it's actionable without you having to establish the damage that was, or the harm that was caused by these actions. As we said, there are 3 or 4 theories we'll look at: assault, battery, false imprisonment, and nervous shock. Then there is trespass to land. Here we have the plaintiff must be in or be titled to exclusive possession of land, and the defendant must cause a direct, again, physical interference with the plaintiff's lawful possession of land. So you'll note everything we're talking about under trespass is direct. Later on in this colloquy, we're going to talk about a different theory, a different cause of action that we call nuisance. And under nuisance, the interference is allowed to be indirect. Okay? Trespass to goods, again, actual or constructive possession of the goods by the plaintiff. Okay? And then there's a direct and intentional or negligent, okay, under trespass to goods, act in interference. Under this trespass to goods, we have 2 theories. Conversion is the intentional denial to return piece goods, okay, and the right to immediate possession by the plaintiff. Détenu, which is larger or wider than conversion, involves unreasonable refusal to return the plaintiff's goods, and when demanded by the plaintiff, okay, when the plaintiff is entitled to immediate possession. Let's focus a bit more now on each one of these theories. Let's start with trespass to the person, and we'll start with the assault. The theory of assault. Now, remember, assault is about fear of harm. So I don't actually have to apply any physical force to the person of the plaintiff. I just have to make a gesture that makes them feel afraid that I'm going to exercise that physical force. Battery, on the other hand, is actual harm. You have already applied that physical force. Okay? So you can, for example, threaten to slap someone. That would be assault. If you actually slap them, then that would be battery. As we said, under the code, the criminal code, this now is just one cause of action called assault, common assault. Then you have false imprisonment. So you have total restraint on the movement of the plaintiff, and there is nervous shock. Let's unpack them a little bit more. So let's start with assault. And the elements for assault are as shown here. There's an intentional act, okay? And the plaintiff reasonably believes that they are in imminent danger of harm or offensive contact. So, arguably, you can actually assault someone by trying to kiss them.
That would be considered sexual assault.
Yeah, if it is an offensive contact, so they don't want you to. Okay? And the defendant intended to cause that fear. So it's a prank, some sort of a prank maybe. Okay? Let's contextualize this with an example. Okay? So we're going to look at some of the cases in your textbook. I'm going to look at the case of Zanker and Fartsokas. So this is on page 622. So this is one of the chapters online, chapter 23. If you have the print off or not, we can share it here from the ebook. Of course, because as I said, it's not going to be even part of your ebook. We have to get it from somewhere else. So all right. So let's start from page 622. So this is a case from 1989 from South Australia, the South Australian Supreme Court. It says Zanker, the appellant, gave the victim, a young woman, a lift in his van. Soon after they were underway, he offered her money to perform sexual favors. So she's in the van. Soon after, he offered money for sex. She refused his offer. She refused his offer, but he persisted. She responded by demanding to be let out of the vehicle, but the defendant responded by accelerating. He told her that he was going to take her to his mate's house, where he will really fix you up. On hearing this, she jumped from the car, which was then traveling at around 60 kilometers per hour. Okay? So the issue here was basically, okay, was her fear of sexual assault at some future time sufficient to constitute assault? Okay. They said that it was, okay, and the comment was, in order for a cause of action assault to succeed, it has to be shown by the plaintiff that there was reasonable apprehension of imminent or immediate and unlawful contact. Okay. So going back to our elements, which is what I'm interested in. Okay. What was here the intentional act by the defendant? Yes?
He wanted sexual favors, but she didn't want to give it to him.
Okay. Is that the only act?
He also accelerated the car.
And what else? By telling her about his mate. Okay? So it's not just one, it's a series of acts. All right. Based on those acts, did the plaintiff here reasonably believe that they are in imminent danger of harm or offensive contact? What is the problem for us in this case? Which word, the operative word, that we really need to deal with? The issue.
They believe.
No. Imminent. Thank you. So the issue here, so as you can see even in the summary that we've just looked at, the comment was, so the issue was, okay, was her fear of sexual assault at some future event or at some future time sufficient to constitute assault? Was that imminent? That's the question.
Most likely because he was trying to ensure that she couldn't escape, so it was most likely.
So that's what they say, see. Okay? So as they say here, the imminent requirement was satisfied and the victim's fear was present and continuing. So my point is, when we go and analyze this, you can see that the first element is not an issue. The third one, the defendant intended to cause that fear. How do you prove that the defendant here actually intended to cause fear? What was the act, the specific one, that really can give us an indication that there was intention to cause fear? The acceleration and the friend. He's gonna take her to this mate and somehow they're gonna beat her up or whatever. Okay, let's look at a second theory. This time around I'm going to look at battery. So again, it has elements. Every cause of action, every section in an act, everything you present in front of a court, everything you analyze in law must be broken down into its elements. So the elements here, that there is a positive act, that it is intentional or negligent, and that it brings about, again, an immediate or direct harmful or offensive contact to the plaintiff, and it is contact that is not generally acceptable in the ordinary conduct of life. Yes?
What does it mean by there is a positive act?
So let's look at an example.
Because positive, it seems like a...
So let's look at page 624, the case of Rickson. So this was from New South Wales, the New South Wales Court of Appeal. Here the appellant had been excluded from a casino under the Casino Control Act in New South Wales. Okay? he's excluded from entering the casino. He was seen by an employee of the respondent, so the casino, the employer of this employee, the casino, and approached him to tell him that he was an excluded person. So he has the right to do so. The employee then placed his hand on the appellant's shoulder without any force and without causing any injury. Just put his hand on his shoulder and asked him to follow him to an interview room. The appellant was detained in that room for about 90 minutes, an hour and a half. So he claimed later that this detention caused him stress and anxiety. The question was, the issue, the legal issue, did the employee's actions in putting his hand on the appellant's shoulder constitute battery? The court said the employee's actions lacked the necessary hostile or angry attitude that was necessary to create in the appellant a fear of imminent harm or offensive contact. So let's enact or react this situation. You are the person excluded from the casino. I'm the employee. I saw you and I came to you and I said, excuse me. Yeah, that would be best. If you stand up, please. Sorry. I came to you and I said, excuse me, sir, you need to follow me to this interview room. Okay? This is what happened in this case. Okay? Yes?
Yes.
Now, what do I need to do to push it to the other side? Grab hold of him. So if I do something like this, that would be angry? What are they saying?
Well, you sort of asked me.
So if I put my hand on his shoulder and tell him to come with me, they say that's okay. You're within your rights. If I come to him and do something like this, for example, give him the eye, or is that going to make him angry?
Probably.
Huh? Is that enough for this to tip to the other side? Thank you. I'm within my rights. This person is excluded. Okay? He shouldn't be here. But even so, you have to use reasonable force. If this amounts to battery, how is it going to amount to battery?
Doesn't the person actually have to be physically harmed before it can amount to battery?
Yeah. So what are we saying here? You asked about the positive act. What is the positive act in this case? No, what from the facts. Always go to the elements, always link this, so as if you're putting this on one side and the facts on the other side and you're trying to draw the lines between them. The positive act here was what? Thank you. This employee putting his arm on your shoulder. That's the positive act. Was it intentional? Did he intend to do so? Tick, tick. It brings about an immediate or direct, harmful or offensive contact to the plaintiff. Was it harmful in this case? Was it offensive? Well, if it was offensive, he would have been found to be guilty of, or liable, depending on which jurisdiction, of battery. But he wasn't. So what would be offensive? So as they told us, there has to be more. What is this more? These actions, the positive act of putting his hand on his shoulder, lacked the necessary hostile. Because if it's hostile, then it is offensive. Or the angry attitude that was necessary to create in the appellant a fear of immediate harm or offensive contact. I come to this gentleman, for example. He's standing in an area where he shouldn't be. Let's say you are the employee. Let's say that he's the person that came to the casino. I'm the employee. Okay? If I came to him and said, "What are you doing here?" What do you think? Is this something that's already a little bit offensive? Or am I still within my rights because he shouldn't be here?
I'd say you're still within your rights because you're an employee there, and if you're a security guard or something, it's your sort of job to.
If I'm an employee at the casino, and let's see if this is actually relevant or not. Do you think that this person would know that I'm an employee of the casino? How are they, someone's nodding yes. How are they going to know that? Okay, so you have identification. Maybe you have a certain uniform, like a security guard uniform. He knows your authority. Let's change the situation. Let's say that this employee was wearing a safety fluorescent vest. He's not wearing a uniform. There's no name tag, just a fluorescent vest. And he comes to you and he says, "What are you doing here?" What would you say? What would you be entitled to do, you think, as a reasonable person?
Maybe ignore him because you think, what's he doing being up in your face? He's got
Okay.
no right.
If you ignore him, probably you will face something even worse. What would you then do? What would be a better option?
Maybe talk to him about what are you talking about?
Yeah, like what? If you are in this situation, what would you do? Someone comes up to you, maybe you know that you shouldn't be there, but someone comes up to you and you don't know their authority. What do you do now? What do you ask? What do you ask for? Ask for an ID. Can I please ask you, for identification? Who are you exactly? Why are you talking to me? Why are you telling me this? Or what else? You could ask for what?
Are you drunk?
Huh?
We can also ask him, are you drunk or something?
Are you drunk? Well, I don't think that's going to be helpful. But a reasonable person would ask for what? So, identification. What else? If he's claiming to have authority, what could you ask him to do? So this gentleman here said that the problem was the uniform. If you have a uniform that identifies your authority, we're on the same page. But you come to me wearing a clown sort of suit, and you come and tell me to leave, something is wrong here. What would you ask for? I would ask for security. Okay? Can you please call someone from security? And then we'll talk. Why? Because I need to see someone with uniform. So I know that there's authority. Unless you decide voluntarily to tell me who you are. And you'd be surprised how many times this happens in organizations and they don't pick up on that point. Whether they want to or don't want to, it's a different story. But they still miss this point. Okay, let's look at something else. We have a lot of these, so we keep moving. False imprisonment. Again, a direct act, and we'll see an example, by the defendant, which totally, and that's the operative word, totally deprives the plaintiff of what? Of their liberty. Is without lawful justification, important, and leaves the plaintiff without any reasonable means of escape. Let's look at one of these cases.
I just want to ask, couldn't this
Yeah.
also relate back to the assault case we looked at? Like, I don't know, because this guy was sort of imprisoning.
Okay, that's a good point. Do you see false imprisonment in what we just looked at?
Yes, I do, because I think is without lawful justification, like he was.
No, but what is the act?
It was a direct act by the defendant.
What's the act? That's what I'm asking you to identify as the act for false imprisonment. Someone maybe can also help. I see it, but where is the act here that you can cite as the positive act for forced imprisonment? The first element.
He was detained in a room.
Thank you. Thank you so much. So, the appellant was detained in the room for about an hour and a half. What's the operative word here? What's the key word? Detained. Detained. What does that tell you, detained?
It means you can't escape.
So, let's take these facts and see if we can go through the elements. A direct act by the defendant. What's a direct act? We're talking forced imprisonment, not assault or battery anymore. The act here is what? Detaining him in the room for an hour and a half. Was totally deprived, i.e. of, we can even join these together, of their liberty. When I say he was detained, what does that mean? Was he able to leave? Okay. Did they lock the door on him and leave him there? Okay. Okay. So far so good. So we can say the first three elements are done. No issues there. Without lawful justification.
Well, actually, that's not one that fit because they say he was not allowed there because he was excluded. So I guess there was lawful justification for keeping him locked up because, again, he was an excluded.
Okay. So we have an argument saying they have lawful justification. This person is not allowed into the casino. They found him on the floor and they have the right to detain him. Okay, let's just quickly go back and look at the other facts. So we said here, the employee placed his hand on the appellant's shoulder without any force and without causing any injury and asked him to follow him to an interview room. Okay, the appellant was detained, during which time he claimed he suffered stress and anxiety. Okay, so one argument, you have justification to do so. Anyone wants to argue in the alternative, to be the devil's advocate? No, they don't have justification. You are actually defending this guy. What would you say?
He was unaware that he was an excluded party.
Okay, he wasn't aware, but how does that affect their justification? They say, their argument, we excluded under this act, this person is excluded from this casino, we saw him on the floor, we have the right and the justification under that to put him into an interview room for an hour and a half. Does that make sense?
Yes.
Okay, you say yes. Someone else says no? Please. So the schizophrenia has to be alive now. Someone? Okay, so what's your Shireen?
Yes.
Okay, so Shireen says, let's pick on the duration. Why an hour and a half? Why would you detain someone for an hour and a half? Why did you take him to the interview room, do you think? Why?
Well, they'd be asking him if he was aware of, to cover themselves, firstly.
And maybe not to make a scene, right? So let's go and talk in this room. Let's not make a scene. Come. And then you explain to him immediately almost, look, mate, we told you not to welcome here. This is a breach of your, legal order not to come. How long is that's going to take? So where did his anxiety come from? Was it just from taking him to the room? Was he left alone for an hour and a half before someone came and talked to him? What is this? So this is where I want you to go. Always try to argue in the alternative. Maybe, even though they have lawful justification, this was over the board. Remember what we said about anger? When you put your hand on someone? Never ever use more force than necessary.
Well, they didn't really when you...
So the last one is simple. Leaves the plaintiff without reasonable means of escape. I don't think this guy was able to do anything about it. Okay? So if you want to pick on something, the legal issue without lawful justification. So if this was an exam part B question, you would simply say, okay, the elements of forced imprisonment are given to us on page 625. You don't even need to list them. Okay? It's on page 625. I see them in front of me. Go see them on page 625. That's good enough. Then you would say, based on the facts, these elements are all made, probably with the exception of the penultimate one.
Well, don't you have to make sure all the elements are met?
So what you would say, one sentence each. So you'd say the direct act was this. The total deprivation and deprivation of liberty was that. And you'd say leaving the plaintiff without a reasonable means of escape is this. So you're taking the facts and saying how this element is made. Then you spend the rest of your time talking about this legal issue without lawful justification. So you put that on top of the page and you do the ILAC. What's the law? What's the facts? And your application and your conclusion.
He was also asked to accompany them to the room. He was not frog-marched. He was not picked up and carried. He was asked to accompany them. He could have refused.
Yes, that's a good argument. But do you think that when he went to the room, he was under the impression that he's going to be detained for an hour and a half? As a reasonable person, I can see it, so let's go to the room and talk. Okay, let's go and talk. But then you leave me there for an hour and a half, for what? You want to say something to me, next time this is so, and then you escort me out, that's it. Yeah? Why do you keep me there for an hour and a half? You're not the police. Even the police can do that to me.
They might have been waiting for the police.
Maybe they have been waiting for the police. Is that something given to us in the facts? And that's what you're going to use in discussion of the issue. Maybe they were doing this. So this is where you have to actually assume or question whether something is missing. There was a book called Maybe, Getting to Maybe. Okay? This was a book that I spent almost every summer reading again and again. Let's see. Just quickly. You don't have to go find it. I think it's also maybe in the library, but this one. Okay? Getting to Maybe. And the idea is that they show you these forks. Okay? You're standing there and there are these forks in the road. Your job is to see them. Okay? Your job is to see them. He's seeing one because he's telling you maybe this is what was happening, but we don't know. So you cite that and you are on your way to an HD. That's what I mean by critical thinking. Okay? Let's keep going. Any other questions? Excuse me. Let's keep going. So that's false imprisonment. Let's go to nervous shock. Okay? And nervous shock, we will have an example on page 627. Again, you need that there has been a positive act. So you know what I'm talking about when I say positive act now. Or statement by the defendant. This act, while indirect, caused nervous shock. And the act was willfully intentional and meant to shock the plaintiff. And the act was calculated to and did directly cause harm. Okay? Let's look at an example. So as I said, there are defenses and remedies you also need to look at. I'm leaving that to you, yeah? Because it might be in the exam that the question is asking you the premise, the counter premise, and we said you always have to identify what the parties want, so the remedies. Okay, let's look at Wilkinson from the UK. All right. So we're saying a guy called Downtown, okay, played a practical joke on the plaintiff, telling her that her husband had been seriously injured. As a result, the plaintiff spent money for a taxi to bring her husband home. She also suffered nervous shock and became very ill. Someone might say, that's ridiculous. Yeah? Who gets very ill because someone just played a practical joke on them? Yeah? A prank. Doesn't matter. So this is what we called back in negligence the egg shell skull. You don't choose your victims. If they have a skull that's so fragile, like an eggshell, then it's your responsibility. If they die from something you've done to them, you can't come back and say, I didn't know that they had, for example, a heart condition. So, the issue, can a person who has willfully done an act intended to cause physical harm to another, and which in fact does cause physical harm, be held responsible for their actions? Okay? So they said this person's conduct was intended to upset the plaintiff and did in fact succeed in doing so. The harm she suffered was reasonably foreseeable, and the effect was not too remote. Remember what we talked about in terms of causation when we talked about negligence? As the connection between the cause and effect was both close and complete. Okay, let's go on and talk about another thing. Trespass to land. Okay, so trespass to land starts on page 627. Okay, that's the menu that you have to prove in terms of elements. All right, and I'll leave it for you to have a look at. Let's go on and talk about trespass to chattels, i.e. to goods. Now, notice that here there are three different types of trespass. Okay? So, either it is an interference of goods called the trespass to goods. So this is generic. Or it could be what we refer to as detinue or conversion. You use detinue, which is the wider cause of action, if you want those goods back. You want to obtain, regain possession of the goods, you use detinue. If the goods have been destroyed already, then the cause of action would be conversion. This is used in cases of deprivation and destruction of goods. As always, there are elements. The elements are given to you in your textbook. I'm not going to go through them again. You can do that on your own. The same thing with conversion. Okay, maybe we can have an example here. So this is an intentional act of dealing with goods on the part of the defendant. Okay, there's a physical dealing with the goods, i.e., for example, selling the goods without effecting delivery would not be sufficient to amount to conversion, but there must be both the sale and the delivery for it to be conversion. Okay, let's look at an example. So we're up to page 631. All right, let's look at this case. High Court of Australia. Penfolds Wines manufactured and sold wine with its name appearing on the bottles. The bottles were to remain the property of Penfolds at all times. This is an old, of course, case. And purchasers were expected to return these empty bottles to Penfolds. Elliot, a hotelier, bought bulk wine and sold it to his customers by filling whatever bottles they brought in. This included the bottles belonging to Penfolds. The legal issue, could the defendant sue for the trespass to goods or conversion? And they said there was conversion. Why? Because there was an act done that was inconsistent with the owner's rights, and then a discussion of what that is. Okay, based on those facts, for conversion, an intentional act, what was the intentional act here? In this case?
Selling the bottles without giving them back.
Yep, so you'd find This is the part. It's just a few sentences. Elliot was doing what? Okay. Sold this wine by filling the bottles they brought in. So the conversion here was the positive act of using those bottles instead of giving them back to Penfords. Was there any physical dealing? So you have to have a sale and the delivery of the bottles. Was there a sale in the terms of the wine itself that was put in the bottles and then giving these bottles to these customers as part of that sale, instead of giving them back to the owners who are this wine company? Of course, these days this situation will not actually materialize. All right, what is detenue instead? Here the difference is that the plaintiff is entitled to immediate possession of the goods, so say the bottles. A specific demand was made for the return. In that case that we just looked at, the wine company did not make a demand to return the bottles. Okay? And the defendant unreasonably and intentionally refused. So Eric or the hotelier would say, no, I will not give you these bottles. Okay? Here, you can obtain these goods back. In conversion, they're gone. They are sold to someone else or they're destroyed. Someone, for example, okay, this is about buying and selling. It doesn't have to be buying and selling. So if I, for example, someone asks me to lend them my, say, laptop, okay, my notebook, okay? I lend it to this person, for example. They take it and then somehow they destroy it or they use it in some way that it doesn't function anymore. That is conversion. Even though I didn't sell it to them, I just gave it to them. Okay, lend me this over the weekend. Okay, here you have it. But then they can't reproduce it. They can't give it back to me. It was stolen from them. It was destroyed. That's conversion. Okay, think about it. Okay, let's look at something else. And this is one of the biggies. Okay, so we come to this cause of action called defamation. One of the hardest ones to establish. Okay, and you have the shortest time to do so. You have a limitation period of 1 year to file in court, not to get the judgment. The 1 year is your time until you are ready to file in court. Let's look at the flow chart for defamation. All right, so just like we had for negligence, there's one for defamation on page 637. Previously, there was a distinction between libel and slander, written or spoken. Today, it's just a statement. It doesn't matter. There's a defamation act, okay, and it's like standardized across all jurisdictions almost. So, there's a statement. Someone made a statement against you. So someone, for example, came and said, this guy has a volatile nature. Okay? And he published this statement. What do you mean by published? So he told it to a third party. Okay? It could be one person. That's enough publication. And every time it's said again, that's a different new publication. What do you understand when I say someone has a volatile nature?
They're choosing to do something, that it's completely in their choice to do something.
So do you think it's something that makes you want to befriend that person? You want to be with them? You want them to be your friend?
I don't know.
So what do you think when I say about someone he has volatile nature? Yes.
They erupt easily. They're like a volcano.
So what is the important word there? The operative word is easily. So if you look at what does that mean, volatile nature? So it says provoked easily towards violence. Okay? So that's the statement. You are the one who was, described this way. So the first thing you have to do is ask for an offer to make amends. There's a lot of money you can make out of this stuff. Unfortunately, it's not as simple. You can go up to 250 now. I think it's 300, or even you can have actually even aggravated damages. But it's not easy, as I said. First, you have to go and make amends. Wasting time. Part of these amends, however, is that you tell them, look, I've suffered from this. I want 250,000. You are entitled to make this offer. It will all go away if you pay me 250,000. You have 1 year to do that. So sometimes law is strategic. It's not like you jump and do things. So it's just like you have this guy or this person, and just enjoy it. Because now you know where you're going with this. It's strategic. It's psychological. But you have to go through these steps, and you have to be 100% better to be 100% sure before you go to court. Because if you end up, it's like a gamble. If you end up doing it wrong, you will end up, they will stick you with the costs of their counsel. Okay? You pay if you take it yourself or if you hire someone else, but then you have to pay for everybody. So you don't get anything actually, and you end up in debt. Or you lose all of your savings or something. We have a lot of people actually at the university who can tell you a lot of stories about this defamation thing. Some didn't know about the limitations period because they found out late. So by the time they got to the lawyer in Brisbane, and the lawyer, I don't know what they were doing, okay? But they lost basically their right to sue. All right, let's go and look at the first step. Is the material defamatory? Why don't we look at an example? So, there is this Mirror newspaper on 637, and it says, have you heard any, I don't have any clips, but have you heard like something about defamation just recently? About one maybe famous Australian actress? Rebel Wilson. Okay, and what happened there? She won, but what was the defamation? Can anyone remember? What did they say about her? Sorry? About her weight? Much more than just her weight. Okay, so about her social class and many other things. Here we have the front page, 1982. The front page of the newspaper contained a statement that a number of people had been arrested and charged over the assault of a member of parliament. So they committed a crime. The report went into some detail about the affair, stating that the arrests were only made after intense investigation had been undertaken by a special squad of detectives. Harrison was one of the people arrested. So the question was, the legal issue, was the newspaper story defamatory according to its ordinary and natural meaning? Did it imply Harrison was guilty of an offense? Have you heard about the Ipswich mayor? What's his name? Pascali? Paul Pisali? What was the story there? When you heard the story in the news with his PJs standing there and reading his statement, what was the key and operative word in everything you heard in the news? That it was always alleged. They never said he committed anything. Okay? Because he might then turn around and say, I'm innocent until proven guilty. Here it was different. This is 1982. They said, so let's see what they said. Decision. They said it was not defamatory. Why? Because it was not capable of bearing the implication that Harrison was guilty of a criminal offense, or that he was directly or even indirectly involved, directly or even indirectly involved. Okay? It merely reported that Harrison had been arrested and charged with assault. Okay? So, what was needed to make the statement defamatory? In this case, if this comes like an exam question, and I want to make it defamatory, what do I have to play with in the facts to make it become defamatory? And then everybody else, of course, comes to the exam with the book, and they just copy. All right. What would change? What do I have to change to make it defamatory? Okay. Someone says maybe they should identify him directly. Was that the operative issue here? Was that really the legal issue? It says arrested and charged.
What if it was still in the process and he hadn't yet been charged?
Okay, would that be defamatory? He has been arrested. Okay, questioned by the police. Is that defamatory? When you're saying that, what are you reporting? Are you reporting the truth or not? If he or those people were indeed questioned by the police, would that be defamatory if I tell the truth? So that's one of the defenses that you can raise in a situation of defamation. It's the truth. He was actually arrested. So how could that be defamatory? I'm just saying the truth. Okay? And in order for you to establish something with the truth or not, it cannot be an opinion. It has to be a fact. A fact. So when I say someone, okay, has a volatile nature, how am I going to establish the fact behind that? Maybe I need to go and get some sort of a psychiatric evaluation on this person, or maybe look at their history. Remember, when we said volatile nature, we said you have to have what? A personality that is easily provoked. Easily provoked. All right. Okay, let's move on. So we said, I don't want to really go through the whole steps. I think by looking at what we did in negligence, you know what's required of you. These are the steps you'll have to go through. Remember, in the exam, when I give you a question, okay, I'm not going to tell you what the premise is. So I'm not going to tell you, would the police or would Harrison be able to succeed on a cause of action defamation? I'm never going to tell you that. You have to find out what the premise is. Okay? All right. Let's then move on to these economic torts. Okay? They are economic because they are trying to protect your profit or business interests, not protect your reputation, although you'll find one of these protects your reputation just like defamation protects the reputation of an individual, which is called injurious falsehood. Okay? Injurious falsehood. So that's where you want to protect the reputation of a business rather than an individual. We also have intimidation. So let's go through them one at a time. and see the elements. This is not from your course book, because your course book doesn't do a good job giving us the elements of this cause of action. So I had to use something from outside the textbook. Okay. So again, the first element is that you have a defendant makes a demand coupled with a threat, intimidation. And this threat is about committing an unlawful act. And the person threatened, so we call them A and B, complies with the demand, thereby causing loss to the plaintiff. The plaintiff is C. A is the defendant. There's someone in between, and this someone was manipulated by the defendant to cause harm to the plaintiff. You can go to this case, the oral case at the bottom, if you want to know more about it. But I think that's all I want to say about it in this course. Let's look at an example. Okay. So we are on page 642. This is Rooks. So economic torts. And let's look at this case from the UK. Rooks resigned from his union after a dispute. Union members then threatened Rooks' employer with an unlawful strike if it did not dismiss him. Rooks was a union member. This is 1964. Okay? So this was a union member, and he decided to resign from the union. The union wants to retaliate, so no one else does the same. So they went after him by or through his employer. They want the employer to fire him, and if they don't fire him, they're going to carry out an unlawful strike. So again, what are the elements? So remember, always the elements will come from the facts. This is what you will have with you going to the exam. You have the stuff with you. It's an open book exam. What you don't have is the facts. So you have to read the facts and map them. So the first thing says the defendant makes a demand coupled with a threat. Who is the defendant? The union. Okay, makes a demand. What's the demand? That they fire Rooks. And coupled with a threat. What's the threat? An unlawful strike. Any problem with this element? So you just write that down. You would say intimidation. You have to identify intimidation. No one's going to tell you what the premise is. And then you would say these are the elements. The first one is made on the facts. The defendant is the union, and so on. The threat is a threat to commit an unlawful act. Yes, the threat here is, as we told in the facts, is an unlawful strike, so it's an unlawful act. No issue here. And that the person threatened, who's Brooks, complies, or Rooks complies with the demand, and the person threatened here is the employer, complies with the demand, thereby causing loss to the plaintiff, who would be Rooks in this case.
What's the threat again?
So what is the threat again? Can someone help us? What did they threaten the employer with? An unlawful strike. Okay? So do you see now whether we call this a crime, whether we call it negligence, whether we call it a contract, whether we call it employment law, unjustified dismissal, anything you want. It will always boil down to elements, and you throw the facts at the elements. And you will find that there's one or more issues there. There's tension, you have to say something, you have to argue. Okay. Interference with contractual relationships. Again, there's a valid existing contract. This would be a very nice twist on a contract question in the exam, right? Because everybody is going to think, oh, this is just about contracts, but you could also have this angle in relation to interference with contractual relations. Okay. Let's look at an example. Lumley and Wagner on 643. Okay, so this is again from the UK. Wagner, a well-known opera star, he must be a Wagner, okay, had been engaged by the plaintiff, Lumley, to sing at the Queen's Theatre in London for 3 months. Wagner, so this is contractual, promised not to perform at any other theatres while under this contract without written consent from Lumley. Okay. Before the start of the opera season, okay, Wagner entered into contract with Guy to sign at another venue for more money, even though Guy was aware of the first contract. What is the problem for us here, or for Guy? The operative fact was that he'd
already entered a contract by another person not to perform for any other person.
That's Wagner's problem. What's Guy's problem? So he knew, he was aware of the first contract. So in an exam situation, if I take that out, that collapses, or at least will make it much harder for you to argue this cause of action. Okay, so this is how you manipulate the facts to come up with different results and see whether you pick up on that or not. Did Guy's actions amount to an interference with contractual relations and bring about a breach of contract? They said Guy's actions in inducing Wagner to break her contract, so it's a her, not a he, with Lumley amounted to a direct and malicious interference with contractual relations. Why? Because he knew. Okay. All right. We'll leave it there. Let's move on to the next theory, which is conspiracy. You've heard about conspiracy probably before from movies. A lot of conspiracy.
Yeah, aliens are real.
Exactly. All right. 4 elements. There's an agreement between 2 or more persons. There's an agreement, just like a contract. Lawful or unlawful means were used with intention to injure the plaintiff's business or other economic interests. Okay. Could this be relevant to some of your scenarios for the assignment? I don't know. Maybe. The 3rd element, the act was carried out and the purpose achieved. Now remember, for the assignment, you are not required to go around identifying cause of action. You are limited to looking at dispute resolution. Some of you, however, have done a very good job actually when they were told in the scenario to talk about litigation, that they went and said, oh, actually this is about litigation and this is most likely to be the premise here. But then they went on and said, but this is not a good idea. Yeah, so litigation is not a good idea. And then they moved back to their dispute resolution method. Okay? That would be an HD answer. Okay? All right. So the act was carried out and the purpose achieved. So this agreement was carried out and the harm, okay, or the injury was achieved and there was actual damage. Okay? Now remember that, okay, I'm not going to go through it in much more detail. Remember that this is also criminal. This shouldn't come as a surprise now. We said that there's really a large overlap between torts and crimes. We saw criminal negligence. There's, for example, criminal defamation. If you go to the Crimes Act, you will find that there's something called criminal defamation. And there's also conspiracy in the crimes, in the criminal code. Passing off. Okay. So passing off on page 645. The elements, you have to have a misrepresentation or passing off. We're going to talk much more about misrepresentation. We talked about it as misrepresentation in terms of a negligent statement, but we're going to talk more about it when we talk about contracts made in the course of trade to prospective customers and calculated to injure the business or goodwill of another trader. Causes or is likely to cause actual harm. Okay? You're given here the example of Hogan and the Koala Dundee. Here the defendant had used images from the film Crocodile Dundee to pass off their products as if they are part of that franchise, as if they are part of the movie. So this part here, the defendant had used images from the film Crocodile Dundee to sell various Australian souvenirs in its shops. The use of such images without authority created the idea of an association with the film. There was a wrongful appropriation of association of goods with an image that belonged to the plaintiff. The federal court granted an injunction, so that's the remedy you would go for, stop them from selling the stuff, to restrain further use of Dundee in connection with the koala image. Now, in some jurisdictions, in Asia or even China, for example, you'll find that they have a lot of passing off. Okay, and of course you can go after them there under the WTO. Okay, but that's really outside what we were talking about in this course. All right, passing off. You know now that there's something called passing off. That was in Australia, so it's a jurisdiction, conflict of laws. But usually you'd go under WTO. This is the counterpart to defamation in the context of a business. So they had an established reputation, the business. Okay? The false statement by the defendant was made with intent to harm this reputation. So it was made with malice. And this plaintiff suffered loss as a result. Okay? So you have to show the economic loss that was sustained. Let's move on and talk about deceit. There's a discussion of misrepresentation on page 647. Okay, have a look at that. We'll go back and talk about misrepresentation in much more detail when we discuss contracts. Deceit, again, has 4 elements. There must be a false statement of fact. The defendant must have knowledge of its falsity. And the defendant must intend that the plaintiff will act on the statement and that the plaintiff does act on it. Remember this overlap between misrepresentation, especially fraudulent misrepresentation. And when you go and look at it in your textbook on chapter 23, there's an overlap between that fraudulent misrepresentation, okay, because that's something you could also sort of raise a cause of action on using this theory of deceit. We'll talk about that again in much more detail when we get to it in contracts. Let's then now talk about a large area called nuisance. Remember, when we talked about trespass, we were looking at direct interference with land rights. Okay? But if the interference is indirect, we could raise something called nuisance, and there are 2 types of nuisance. Okay? One of them is public and one of them is private. Public nuisance has the following elements. Okay? Now remember, if you go and look at something else, like for example, a law textbook, this is just for business students, this textbook. If you go and look at a law textbook, they might have a different elementization. That's fine, okay? This is what I want you to know. This is what I want you to take with you to the exam. Okay? Keep it simple. So it says here, a plaintiff, normally the state because it is public, but it can be a private individual if they can show that they have suffered a greater loss than the public. This plaintiff must establish first that the nuisance was substantial and unreasonable and materially affected the reasonable comfort and convenience of life of a class of the population of which the plaintiff was a member. This is the important part. You have the, what we call standing, to bring this cause of action because you are part of a class of the population. Okay? So, someone, for example, is operating a coal generation power plant next to you. Okay? And there's this community, okay, next to this power plant that would form a class of the population. So any one of these individuals can bring this public nuisance against the plant. So this is indirect interference because the interference is coming through this carbon dioxide or this emission that's coming out from the plant. Okay? So you have to prove the practical damage over and above that suffered by the public, so people who are not next to this plant, because of the nuisance. You've heard, of course, of many cities, even in Flint, Michigan. Has anyone heard of Flint, Michigan? They have a problem with water there. Okay, same story. You can also bring that in that situation. Okay, so is there an example we can give you, or we can leave it for something later on when we go to Springfield? So keep an eye on this. We'll talk about this in some more detail. Not necessarily maybe public nuisance. All right. Then there's private nuisance. Again, indirect, substantial, unreasonable interference, okay, with the use or enjoyment of land by the defendant. Always remember, nuisance has to do with land. It's just like trespass to land. But here it's indirect interference, not direct interference. You're not going into the land yourself, but something you have done, something you have generated, something you have caused. Okay? Now these are the factors you need to look at to decide whether the interference was reasonable or unreasonable. Things like duration, locality, gravity of the harm, motive, and alternatives. Okay? Keep that in mind for now. We'll come back to it. And there's breach of statutory duty. We looked at that as well when we looked at things like non-delegable duties, Chapter 6 stuff. But there's, a cause of action on its own called breach of statutory duty. These are the elements you have to go through. And the last one I want to talk about today is invasion of privacy or privacy. And this just gives you this idea of the evolution of legal theory. So over time, you see that we are creating new offenses, new legal theories, new causes of action. This is the latest. Okay? So there's now, and again, in different jurisdictions, there's different sort of speed in terms of bringing about change to the existing legal system. Okay, we'll leave it there. Let's stop now for 10 minutes. We'll start again at 9:35 on our tutorial. Thanks.